Well, let's get a view on this now from William Booth. He's a well-known criminal attorney. He's a director at William Booth Criminal Attorneys. William, good afternoon to you, and thank you for your time. When a defense advocate makes a claim like this, as Malesala Teffo did in open court, that he will bring a witness, an eyewitness, who will say that this person pulled the trigger, what happens from here? Does he actually have to bring a witness to say that in court?
Good afternoon, Stephen. Yes, absolutely, he must do so. Otherwise, that evidence is totally irrelevant and cannot be taken into account at all when the judge has to consider the case and determine the guilt or the innocence of any of the accused. So I think the point to be made is whether this was raised previously, because this is a clear defense that he has. In other words, somebody else did it, shot, and it was as a result of an accident. And I believe he needs to disclose the name of that witness during his cross-examination. But my view on it is, if that is the case, and he's been in possession of this information previously, let's say at the time that the charges were put, that should have been stated in court and be part of his defense, because it's crucial to his defense. In other words, he didn't do it, it had nothing to do with it, somebody else was involved in the actual shooting. But, the question is, it has no relevance until that witness is called, and one would wonder with the initial investigation why that aspect wasn't considered. I mean, when you're arrested on a case and you have information that's vital to your defense, I mean, I believe it's in your own best interest to disclose that upfront, that can be investigated and, possibly the charges even be withdrawn against you before the trial starts.
This must obviously be hugely distressing for Kelly Khumalo, for her family, for the Meyiwa family, other people too. This claim is made in open court. We've all seen it. That clip has been played, everywhere and will be played many times still. If he doesn't then sort of bring this evidence, if he doesn't sort of put up his evidence, I mean, does Kelly Khumalo have any kind of move against him? Does she have any recourse?
Well, my view is that if you make this allegation in open court against somebody, then you must have that evidence, you must have an affidavit from that witness and make that witness available. Obviously, if the witness suddenly disappears or there is some change in the whereabouts of the witness, he has to advise the court of that fact. But you cannot make such an allegation if you're not sure, A, who the witness is, one would assume he does know, and B, that you have an affidavit, a statement under oath made to a commission of oaths from that witness, and that witness is indeed available. You can't just make allegations left, right, and center in court, in any court. Doesn't matter what type of case there is against your client. And if you're making an allegation which affects, let's say, the credibility of another person like Khumalo, then, there is possible sanctions. The matter can, be referred to the Legal Practice Council if these allegations are followed up and found to be incorrect and it's merely just a smokescreen. So I trust he's got the information, he knows who the witness is, and that witness will be called at some particular point during the case, certainly by the defense.
The people who were in the house on the night, now I wasn't there, you weren't there, but the people who were in the house on the night know who they are. He says that this is an eyewitness. So the people in the house will know who it is my point. So is there any reason why Advocate Teffo could not say now who his witness is? I mean, would it be wrong for him to do that?
Well, I believe, that is something you must say, because you must put it to whichever witnesses you are cross-examining and say this person was in the house, obviously an eyewitness. He or she must have been there to be an eyewitness. And why is there some secret? Unless he brings an application to court deals with this whole issue in not in open court, but in camera, saying there are risks to state openly at this stage the identity of the person. But then, there's a procedure to follow if that is a concern, of the defense. But, I mean, you don't cross-examine a witness and just leave it up in the air. You must say, I have got this witness, the name of the person. And one would, as I said earlier, have thought, if the police have done the investigation properly, and this person is an eyewitness and being in the house, that they would already have interviewed that particular witness.
We've all seen the evidence of the first police investigating officer on the scene, Sergeant Thabo Mosia, and the claims against him in terms of the cross-examination from the two defense lawyers. So he didn't take lots of cameras, people were allowed to sleep in the house overnight, even though it was still an open crime scene, all of that. But it did remind me of a case, you may have heard of it, you may remember it, the Oscar Pistorius case. For the first few moments during the cross-examination of the police officers who were there, I mean, you would have thought there wasn't a case. But by the end of it, you realize that there very much was, and in fact, Oscar Pistorius was found guilty. Do you think the same thing is going to happen here? It looks at the moment, the forensic person did this, the investigating officer didn't do that, but actually in the end, their evidence may well stand.
Well, look, with regard to the collection of forensic evidence, it's very clear, and this is accepted by all our courts. When a forensic investigator, somebody who's coming to collect, evidence, he has to cordon off the crime scene, or certainly the first police that arrive should cordon off the crime scene. And when the investigator, the forensic investigator, arrives to collect evidence, he's got to make sure there is set requirements that the police have with regard to these investigators. He's supposed to be an expert. So he needs to know what requirements are necessary, because at the end of the day, the court has to determine that all the forensic evidence collected has been properly collected. There has to be a chain of custody from the collection point all the way to the time that evidence is tested. Let's say it's DNA evidence or ballistic evidence, ends up with a ballistic expert at a laboratory, who then has to do certain tests on, let's say, ammunition or a firearm or on DNA. And, that chain has to be carefully managed, because if there's any break in the chain, that can affect the evidence being accepted by the court, because it could be contaminated. So contaminated evidence, there's a problem with accepting it. So that's why you arrive on the scene, you make sure you're taking photographs, you do it properly, you collect the evidence properly, you then prepare an affidavit or a photo album of whatever you picked up, on camera at the crime scene. You make sure that is then put in an evidence bag, handed into a specific exhibit store. Nobody has any contact with it until it gets to the forensic laboratory for whatever test must be conducted. Because then if you have a break in the chain, that can have a serious effect. But again, it depends. So in Oscar's matter, that I think we all know very much about, and we've all commented at some point, at the end of the day, that maybe didn't play such a significant role. But in a particular case where, let's say, DNA evidence is the only evidence, or ballistic evidence is the only evidence, you don't have eyewitnesses or other evidence, then that could potentially lead to an acquittal if the chain of evidence isn't secured and there's been a break in the chain and there's been contamination.
William Booth, thank you very much indeed. Really do appreciate a very succinct explanation. Director at William Booth Criminal Attorneys. Well, more, of course, to come. Senzo Meyiwa murder trial back in court from 10 tomorrow. In a moment.